decision in Mbenjo Amalgamated Limited versus KCB, where the Court of Appeal defined inherent power as the authority possessed by a court implicitly without it being derived from the constitutional statute. The Attorney General, in addition, submits that this application seeks clarification on a matter of grave public interest whose importance cannot be overemphasized. To support this argument, it relies upon the case of Speaker of the Senate and another versus the AG to emphasize that the Supreme Court's obligation as set out in Section 3 of the Supreme Court Act must prevail. Upon being reminded by the court that the Attorney General's submission as amicus curiae in the petition was specific that he should not address the minor KI decision, Mr. Bitter State Counsel, appearing on behalf of the Attorney General, limited his submission to the inherent jurisdiction of the court as was determined in paragraph 91 of the Fred Outa case. He argued in that regard that there is necessity to have clarity in the conduct of presidential elections, as it is a matter of great public interest to the extent that it was a ground for nullifying elections, the second respondent having been faulted for not following the process envisaged in law. He added that the ambiguity sought to be clarified relates to what amounts to verification of results, which is an important issue. He concluded by reiterating that the second respondent has amply demonstrated the ambiguity in the judgment that needs clarification. The second amicus, in their written submissions dated 10th October 2017 and filed on the 11th of October 2017, the Law Society of Kenya submitted that there is no ambiguity identified in the judgment of the court which calls for clarification or enhancement of comprehension and appreciation of the court's intention. They thus refer to the notice of motion application and submit that the application does not identify any error or provide for a way of correcting the error, but has only set out questions of the court to answer. Further, that the applicant is seeking a plain opinion stated on his functions under Article 138(1) and 86(3) of the Constitution. The Law Society in that regard urged the court to disregard the groundbreaking decision Fred Outa case, being relied upon by the applicant who does not appreciate the court's holding, in that case discounting any possibility of applying Article 163 of the Constitution in an application such as this one, and that the main purpose of Section 21(4) of the Supreme Court Act is to steer a judgment, decision, or order of this court towards logical or clerical perfection. It is their submission that the principle of the slip rule that a court has residual jurisdiction to review, vary, or to rescind its decision in exceptional circumstances as enunciated in the Court of Appeal case of Ngurumani Limited had not been met. Thus, this court should disallow the application. On the issue of costs, the Law Society of Kenya's submission is that this court should not award costs on an application concerning a matter in which a party seeks purely to be guided on its state officer duties. However, during hearing before us, Mr. Mwenesi, advocate for the Law Society of Kenya, rose to highlight his client's submissions. However, during hearing, before Mr. Mwenesi, advocate for the Law Society of Kenya, rose to highlight his client's submissions, Mr. Karori, advocate for the second respondent, raised a preliminary objection as filed on the 11th of October 2017. The The objection sought to expunge the submissions by the Law Society of Kenya on the grounds that they had exceeded the scope within which the said society had been admitted as an amicus curiae. Mr. Karori submitted in that context that the Law Society of Kenya was expected to limit its submissions to the interpretation and application of Section 83 of the Elections Act, but had instead responded to the application and taken a partial position. That an amicus curiae is not supposed to pursue an active position and outcome, as that is left to the parties to the dispute. On that submission, Council relied on this court decision in Trusted Society of Human Rights Alliance versus Momo Matemo and 5 others. Mr. Mwenesi was, upon the objection being raised, accordingly guided by the court to limit his submissions to the interpretation and constitutionality of Section 83 of the Elections Act. He thus submitted that in compliance with the law, the result notwithstanding, the first respondent has not set out any ambiguity in Section 83 as interpreted by this court to warrant the present application. That paragraph 294 of the judgment does not raise any doubt or ambiguity in his view, contrary to the second respondent's submission. It is his argument instead that Article 138 of the Constitution is in tandem with the announcement and declaration of results and the first respondent's anxiety that the court may have gone overboard does not arise. He referred to Article 10 of the Constitution as being instructive on the interpretation of the Constitution and submitted that the court cannot confer more mandate beyond what is provided in the Constitution. The first interested party's submissions. By its written submissions dated 10th October 2017, the first interested party opposes this application on the grounds that, firstly, the application seeks an interpretation of Articles 138(3)(c) and 138(10)(a) of the Constitution, yet this court has no original jurisdiction to interpret the Constitution, and that this application ought therefore to have been filed in the High Court. He relied upon the case of IEBC, Supreme Court Application Number 2 of 2011 on the competency of the court to interpret the Constitution. The first interested party also refers to his application in this petition dated the 6th September 2017, in which this court, in making an order declining to hear the application issued on 21st September 2017, observed that it has no original jurisdiction to interpret the Constitution, save as stated in Article 163 sub 3 and 6 of the Constitution. It thus urges the court to strike out this application on the ground of want of jurisdiction, in that it is similar to the one dated 6 September 2017. Secondly, that the subject matter for clarification herein is res judicata, having been fully and finally determined and settled by the Court of Appeal in the minor KI decision. In this regard, it relies upon the Court of Appeal decision in Uhuru Highway Development Limited versus the Central Bank of Kenya. Thirdly, that the court is now functus official, having pronounced itself with finality on the matter via its determination delivered on 1st September and the reasoned judgment on the 20th September. He makes reference to the English Court of Appeal case where the court held that there are two exceptions to this rule, namely, where there had been a slip in drawing it up and where there was an error in expressing the manifest intention of the court. The first interested party thus urges the court to dismiss this application and find that the applicant has not demonstrated any error apparent on the face of the said judgment that requires correction hence the exceptions herein do not apply. Mr. Mutuma, for the first interested party, reiterated the above position, adding that the High Court is best suited to address the application. He further submitted that should this court grant the application, it would inevitably review the Court of Appeal decision, and the court should resist the temptation to do so and instead strike out the application with costs. Our determination. Having heard and considered the submissions by the parties, the following is our opinion. On jurisdiction, at the outset, it is important to determine whether this application is properly before us. On this question, we have considered the written and oral submissions by all the parties, including the amicus curiae. There's no doubt in our minds that this is a unique, if not an extraordinary application, for it is neither an appeal nor a reference for an advisory opinion. Although the applicant has therefore invoked Articles 138, 159, and 163 of the Constitution as the foundation for the notice of motion, we do not see how these provisions can be a basis for us to assume jurisdiction so as to determine the questions as framed. At best, it may be said to be an application for review of this court's judgment delivered on the 20th September 2017. This may also explain why the notice of motion is also brought under Section 21(4) of the Supreme Court Act, for it seeks to correct or clarify this court's judgment. Yet, given this court's decision in the Fred Outa case, it is doubtful whether, strictly speaking, Section 21(4) of the Supreme Court Act has been properly invoked as a jurisdictional basis for the application. That section provides as follows, quote, within 14 days of delivery of its judgment, a ruling or order, the court may, on its own motion or on application by any party with notice to the other or others, correct any oversight or clerical error of computation or other error apparent on the face of such judgment, ruling, or order, and such correction shall constitute part of the judgment, ruling, or order of the court, unquote. At paragraph 86 of the Fred Outa case, this court pronounced itself thus, quote, Section 21(4) of the Supreme Court Act does not confer upon this court jurisdiction or powers to sit on appeal over its own judgments. Neither does it confer upon the court powers to review any of its judgments once delivered, save to correct any clerical error or some other error arising from any accidental slip or omission, or to vary the judgment or order so as to give effect to its meaning or intention. The main purpose, therefore, of Section 21(4) of the Supreme Court Act is to steer the judgment, decision, or order of this court towards logical or clerical perfection. End of quote. The jurisdiction granted by Section 21(4) is in consonance with jurisprudence from comparative jurisdictions. We thus concur with the persuasive authorities of the decisions of the High Court of Australia, cited by counsel for the petitioner, where it was held that controversies once resolved are not to be reopened except in a few narrowly defined circumstances, and that of the decision of the Supreme Court of Philippines that the doctrine of finality or imputability of judgment stands. It is that clear that Section 24(1) of the Supreme Court Act grants the court very limited powers or room to tinker with its judgment or orders once delivered. Towards this end, we sought to know from Senior Counsel Mr. Mwite as to what aspects of the judgment delivered on the 20th September 2017 the applicant wanted corrected. And response counsel was categorical that the application did not in any way seek to correct the judgment of this court. What the applicant was seeking, urged counsel, was a clarification of the issues as framed in the notice of motion. Mr. Kiragu, counsel for the third respondent on his part, had difficulties as to how to classify this application, but nonetheless urged the court not to dismiss it offhand, given the immense public interest in the subject matter as framed. The petitioner and the first respondent and the first interested party have on their part strongly urged the court to dismiss the application for want of jurisdiction. This sentiment was supported by the Law Society of Kenya as the second amicus curiae. Counsel for the first interested party submitted in that regard that this court needed to be consistent in the manner it determines applications before it. In his view, the application before us was similar to the one brought to this court recently by the first interested party, in which he sought an interpretation of the meaning of the words fresh election in Article 140, Subarticle 3 of the Constitution. The application was struck out on the ground that the proper forum for the determination of that issue was the High Court. Counsel therefore urged us to treat the present application similarly and remit the same to the High Court. We have considered all submissions as to whether this court has jurisdiction to entertain the application or not. From our sentiments expressed in the foregoing paragraphs, it must be clearly discernible that we entertain serious doubts as to whether this court has jurisdiction to clarify its judgments. Having pronounced ourselves authoritatively on the issues that were placed before us in petition number 1 of 2017, it was this court's expectation that all parties thereto would act in accordance with what they understood the court to have meant. This application does not also fall within the purview of Section 21(4) of the Supreme Court Act. This court has no jurisdiction to interpret its decisions or those of other courts. On the face of it, therefore, in ordinary circumstances, an application which is based on tenuous jurisdictional foundations, such as the one before us, ought therefore to be dismissed. However, we are keenly aware that the questions whose clarification the applicant seeks arise from the recently decided presidential election petition, a determination that continues to elicit considerable public interest. It is also our view that this application is not similar to the one by the first interested party that was recently dismissed by this court. In that application, the applicant had sought an interpretation of a constitutional provision as a matter that was not an issue in petition number 1 of 2017. Had this court entertained the application, it would have usurped the jurisdiction of the High Court, contrary to its established traditions and tenets. We have, in the above context, critically considered the submissions made by Messrs. Muite and Kiragu, urging us not to turn the applicant away given the enduring public interest in the judgment that has triggered the application. To that limited extent of great public interest, we think that the submissions by the two counsel are not without merit. In exercise of the inherent powers of this court, we shall therefore proceed to determine whether there is any matter to be clarified, and if so, to what extent. This assumption of jurisdiction is all the more necessary so as to avert the danger of an impression being created in the mind of the public that there exists an ambiguity in the court's judgment, even where there might be none. If indeed there is an ambiguity, the assumption of jurisdiction will help eliminate the same. Having so decided, we now turn to the two questions as framed in the notice of motion. The applicant poses the first question thus: which results as between the tallies contained in Forms 34B as submitted by the returning officers to the National Tally Center and the totals of Forms 34A as verified by the first and second respondents, the second respondent should use in declaring the results of the presidential election as envisaged under Article 138(10)A of the Constitution. With due respect, we find this question as framed either mischievous or informed by an inexplicable lack of understanding of the Constitution, the Elections Act, and the judgment of this court, not to mention the judgments of the Court of Appeal and the High Court regarding the duty of the first respondent to verify, accurately tally, and transmit the results of a presidential election, coupled with the duty of the second respondent to verify, accurately tally, and declare the results of the election of the president. These stages and responsibilities are so elaborately explained in the judgment of this court that it confounds the mind that the second respondent would pose such a question. The way in which the question is framed appears to be based on the assumption that the results in Forms 34A and those in Forms 34B are mutually exclusive. It is not a rudimentary fact that the latter, is it not a rudimentary fact that the latter is the aggregate of the former? And if this is so, how would it be a matter of choice as to which results between Forms 34A and Forms 34B the second respondent is to declare. Who aggregates that into what? Again, is it not an established fact that the constituency returning officer aggregates forms 34A from the polling stations into form 34B? Before generating form 34B, does not the returning officer verify the figures in forms 34A? Is it not a fact that the second respondent, as the national returning officer, aggregates the results from forms 34B into form 34C? Did this court not categorically state that before declaring the final aggregate results in form 34C, the first respondent on behalf of the second respondent must verify the said results against those in the transmitted forms 34A? Is this not why form 34A is considered the primary document in the verification process? Is the verification exercise not meant to establish the accuracy or otherwise of the results, which is a basic tenet of the Constitution? If the second respondent notices some inaccuracies as brought to his attention by the first respondent, what is his duty? Is he not supposed to simply bring those to the attention of the candidates, the public, and the election observers, even as he declares the final result as aggregated from forms 34B? What did this court say about the effect of inaccuracies that may be unearthed by the verification exercise on an election? At paragraph F of the notice of motion, the applicant states that despite agreeing with the finding in the minor KI case at paragraph 294 of his judgment, the Supreme Court criticized the reliance by the first and second respondents of the minor KI case for the position that any errors identified by the first and second respondents in the verification can only be corrected by an election court. The court emphatically stated that in the course of verification, the numbers must add up. We do not understand the genesis of the foregoing assertion by the applicant. Nowhere in its judgment, in the majority judgment, did this court criticize the first and the second respondents' reliance on the minor KI case. On the contrary, what this court took issue with was the decision by the second respondent to declare the results that had not been tested against the transmitted results in forms 34A from the 40,883 polling stations countrywide. This court disagreed with the first and second respondent submission to the effect that the minor KI decision had relieved them of the duty to verify the results against forms 34A. This was clearly stated by the Court of Appeal at paragraph 293 as follows. Quote, "It was further urged in court by a number of counsel for the first and second respondents that by disregarding forms 34A and exclusively relying on forms 34B, the said respondents were simply complying with the Court of Appeal's decision in minor KI. We have already held that we find little or nothing in this decision to suggest that by deciding the way it did, the appellate court restrained or barred the first respondent from verifying the results before declaring them, or that it was relieving the former from the statutory duty of electronically transmitting the results. What the second respondent was barred from from doing by the Court of Appeal and the High Court was to vary, alter, or change the results relayed to the National Tallying Center from the polling stations and constituency tallying centers under the guise of verification. End of quote. So, where does the need to clarify such a pronouncement by this court emanate from? We reiterate that the responsibility to verify results is not a creation of this court, but an imperative of the Constitution and Section 39, 1C, B of the Elections Act. The verification required of the first and second respondents is meant to ensure accuracy or prevent fraud, and also to confirm that the candidate to be declared president-elect has met the threshold set under Article 138(4) of the Constitution. It is therefore the duty of the second respondent to bring to the attention of the public any inaccuracies discovered by the verification of Forms 34A and Forms 34B, even as he declares the results as generated from Forms 34B to generate Form 34C. The effect of such inaccuracies on an election depends on their gravity or otherwise, and the second respondent must state whether the discrepancies affect the overall results or not. The institution vested with a mandate to make a determination of the effect of the inaccuracies is an election court, a matter clearly settled by both the Court of Appeal in the minor Kiai case decision and in this court's majority judgment. This brings us to the second question, which is whether the first and second respondents can correct errors identified in Forms 34B and or amend the Forms 34B where the same differ with the results contained in the relevant Forms 34A after the verification exercise envisaged by Article 138(3)(c) of the Constitution. To this, the answer is rather obvious. The issue was dealt with in the minor Kiai decision by the Court of Appeal, but for whatever it may be worth, we hereby reiterate that the first and the second respondents cannot correct errors identified in Forms 34B or amend the Forms 34B where the same differ with the results contained in the relevant Forms 34A. Theirs is to expose such discrepancies and leave the resolution of such issues to the election court, in this case, the Supreme Court. This opinion represents our understanding and answer to the two questions posed before us by the second respondents, and there shall be orders accordingly. Thank you very much.
Much obliged.
My brother, Professor Judge, will read a short one.
Much.
Following the delivery of the majority judgment on the 20th of September 2017, a judgment